All right, looks like we've got a good number of people have joined onto the call. And so we'll start with the intro and then we'll get into the bones of the presentation. Thank you to those who joined us on Tuesday for our presentation on the 5 steps to a secure retirement. And thanks for coming back on again, or thanks to those of you that are new to this presentation. So we really appreciate you joining us. Today, what we're going to talk about is the 7 deadly sins of estate planning. And Keith Masterman has joined us from CI Investments. And you have myself, Per Homer, from Asante Wealth Management. And Keith is going to do the majority of the presentation. He is a fantastic expert. He is a lawyer. And we've done this presentation before, and people really enjoyed it. So I'm going to give you a little bit of an update just on who we are. So this is our team. On our team, we've got Jeff Wachman, who's been advisor with Asante for longer than he'd care to admit. Myself, Per Homer, and Jeff and I have been working together now for over 5 years. And then recently last year, Erik joined us, which is fantastic. And we also have Shay and Leah, who work closely with us and make sure that we stay on track. So this is our team. Asante's got about 850 advisors across Canada. So and is part of the CI family. One of the two things that, or one of the things that I want you to learn out of the 2 presentations that we've done, and I showed this slide on Tuesday, is that if you don't plan, you won't succeed. So as Benjamin Franklin said, if you fail to plan, you're planning to fail. And so really important when it comes to planning for your retirement and doing a financial plan, but it's also really important when planning for your estate plan. So what's going to happen in the next phase of your life? So when you've moved on to the next realm, or whatever it is your belief set says, then what happens after that, and how do you plan for your heirs, loved ones, children, spouse, partner, etc., dog, whatever you want to do. And so this presentation will be given by Keith Masterman, who's also, you can see him on video here. I'll probably put myself, turn off my video and mute myself so you can pay full attention to Keith. And then I'll chime in every so often with the questions that you guys put in. Please put them in the Q&A section or the chat, and we will be more than pleased to field your questions. I know on Tuesday there were a lot of excellent questions, and it's really a lot of fun to give a presentation when you get some really well-considered, thought-out, and intelligent questions. So Keith Masterman, Vice President CI Investments, will be talking now about the 7 deadly sins of estate planning. And without further ado, please go ahead, Keith.
Great, thanks very much, Per. So my presentation, 7 Deadly Sins in Estate Planning, really is a conversation about things that I've learned over my career. I'm an estate lawyer. I did a lot of estate litigation, a lot of estate planning for high net worth Canadians, and an awful lot of estate administration. In fact, this presentation was originally called 7 Things That I've Seen That Have Gone Wrong in People's Will Plans over the last industry, until she retired a couple of years ago. Said to me, one of her jobs was to come up with headlines that would actually make you want to buy the paper. And she read my headline and she said, you know what, no one's ever going to come to a presentation by you. That's a terrible headline. So she came up with this one. So if you like the headline, it's because of my wife, Chris. If you don't like it, chances of you meeting her are pretty remote, so I think I'm okay. At any rate, what I'm covering today are things that I've seen that have gone wrong in estate plans over the last 34 years. And really what I'm hoping you could take away from it is just 2 or 3 things that when the next time you look at your will, you say to yourself, you know what, that's something I should look at. We're concentrating on wills today. Powers of attorney are very important too. I have an entire presentation about them, and perhaps some other time we'll talk about those. So let's move on to the next slide and talk about what the sins are. Yep, there we go. So the sins I'm going to talk about today are no estate plan or an outdated plan. And, you know, I think the statistic that I read recently was that 56% of Canadians don't have a will. But even more shocking, or perhaps more shocking, is that 30% of the Canadians who do have a will wrote their will when their oldest child was born. And that's who I was. So I'm going to use myself as a bad example when we get to that sin, because I'm a grandfather 3 times over. And when I read that statistic, I realized my will was written when my oldest son, Jack, was born. And so I'll use myself as an example of why that's a bad thing to do. We're then going to talk about incorrectly named beneficiaries. So, you know, the law has changed an awful lot about how you name beneficiaries. And we're going to talk about, for instance, when my 3rd grandchild was born about a year ago, Jack was telling me that today there's, on the birth registration, parent 1, parent 2, parent 3, parent 4. When I registered my son and daughter's birth, there was mother and father. But the definition of parent has changed in Ontario. And so has the definition of child and a whole bunch of other things. So when we look at our wills, we've got to make sure that our beneficiaries are described in a way we want them to be described. We'll also talk about charitable benefits there. Inappropriate choice of executor. I'm not going to tell you all the wonderful things an executor does. I'm sure you've been to presentations before where someone like myself talks about the 70 or 80 duties of an executor. I'm going to talk to you about the conversation I had with my executor when I named him my executor. My executor, spoiler alert, is my oldest son, Jack. And when I named him as my executor, I was worried about what it would do to the family, and I was worried about his liability. So we'll talk about that. We're then going to talk about ignoring assets of sentimental value. And it has always been my firm belief that my only job as an estate planning lawyer is to make sure that your family can still have dinner together after you pass away. And I think where I see families blow up all the time is not over the money. It's over those sentimental value assets, grandma's china, grandpa's watch, whatever it might be. And we're also going to talk about digital assets at that point because it's so important in your will plan to deal with your digital assets. We're then going to talk about lack of care and registered product designations, your RIFs and your RSPs. And you know, there was a case a few years ago called Ree Morrison from Alberta, and it changed the law a little bit about beneficiary designations. However, and there was a case in June of this year called Kelmosky, and it changed the law of beneficiary designation. So we're going to talk a little bit about that. The next thing we're going to talk about is inappropriate use of probate minimization. So I'm sure you all know what probate is. It's that tax that's payable on your death. They add up the value of all the assets going through your estate. They multiply by 1.5%, and you pay that to the government. I want my son to get probate. I think it's really important that he does so because it protects him, and we'll talk about how when we get there. But for purposes now, I don't want him to get it on all my assets. I want to minimize it as much as possible, and we'll talk about the tools to minimize. And then the last thing we'll talk about is failure to consider the words in your will. I think all of us have read the first 2 pages of our will. Those are the pages that say everything to my spouse or my children or charities or your church or whatever it might be. And then we ignore the last 9 or 10 pages. They're not there because your lawyer gets paid by the word. They each mean a specific thing. And we'll talk about why it's important to read those words and understand what they mean. So with that rather long introduction, let's move on to our first sin. And that is...
Right. So I'm just going to cut in, Keith. We are aware that there is some audio issues with respect to Keith's audio. Unfortunately, because of COVID, we're all working in a distributed fashion, and so we're doing the best we can. But hopefully, you are getting the majority of the audio, and it's working great. So thank you all for pointing that out. We're doing the best that we can on that front. So thank you. Yeah.
Do you want me to phone and have the video and me on my phone?
No, I don't think that's going to change it. So just we'll just keep going this way, and that'll work. Yeah. Just stay close to
great.
The computer, I guess, is the solution.
Okay.
Yeah.
Okay, here, I'll move it way over here so you see my face really big. Okay, so the sin number 1 was no estate plan or an outdated estate plan. And you'll see a statistic up there, but the one I like to use because it's a little more new is the one I told you earlier, that 56% of Canadians do not have a will. And of those that do, 30% wrote their will when their oldest child is born. And as I said, I'll use myself as a bad example about why you don't want to be in that 30%, why you want to look at your estate plan from time to time. Because I'll tell you how my life has changed in the last 34, 35 years. Well, the first thing is, I told you I'm a grandfather, so clearly I now have a daughter-in-law and I have 3 grandchildren. And my will was completely silent on those people in my family. And so what will happen if my son Jack gets divorced? Nothing in my will talked about that. And it might be that I still want my daughter-in-law, Kelsey, to receive some of my estate because she's the mother of my grandchildren and I love her very much. She's a wonderful part of my family. But my will is silent on what I want. It might be that I want my estate to stay with my son Jack, and I can do that too. But again, my will is completely silent. The other thing that changed is I now have 3 grandchildren, Farley, Winston, and Louie. And they're cute as anything. And of course, my estate said if Jack dies, it goes to his children, but I didn't know them then. And now I do. And there might be things around the house that I want to make sure go to them. Or it might be that I want to help with their education or help with their sports or whatever it is. And I can do that in my will. But of course, my will was silent. That's 34 years old. The other thing that's changed over the last 34, 35 years is Chris and I are doing a little better. 35 years ago, how we lived was hand to mouth. Chris would get paid and we'd spend the money on crazy things like groceries and heat. And I'd get paid the next week and we paid on silly things like the mortgage. But now we've got a little bit more wealth. And so I can use my will for other things than just handing my money down. I can use it to hand my values down. Handing your money down is pretty easy. But a lot of Canadians now are saying, how can I transfer my values or let my children know what my values are in my will? And a lot of that's through charitable gifts. So I have some charitable gifts in my will, and we'll talk about that in a few minutes. But of course, 34 years ago, I didn't have the wealth to put those in place. And those are there not only to provide a gift to a charity that means a lot to me, it's also to say to Jack and Hannah, those are my children, hey, look, you're important to me, but so is giving back to my community. So is involvement with society in general. And the biggest change in my last 34 or 35 years is I have a daughter. And clearly my will that was 34 years old said, divide my estate by my children once Chris and I are finished with the money. But I didn't expect 34 years ago that I would have a disabled beneficiary. But I do. My daughter was born with 2 fairly mild but important disabilities that I deal with. And of course, I didn't plan for that. And so, there's an awful lot of planning around disabled beneficiaries. There's a trust in Canada called a Qualified Disability Trust. And what that means is I could take Hannah's portion of the estate and put it in a specialized trust. And by wording that trust correctly, I could preserve her provincial benefits to Ontario disability pension plans and stuff like that. Or I'm sorry, provincial benefits. I could preserve her benefits for that. And also that trust would have graduated tax rates, because every other type of trust I create in my will, whether it be a spousal trust or a trust for a spendthrift beneficiary or whatever it is, every other type of trust, every nickel that's created in that trust, so every nickel that's that investments bring forth in that trust is taxed at the highest marginal tax rate, which in Ontario is 53.53%, unless it's paid out to the beneficiary. But a qualified disability trust doesn't have that. So there's an awful lot of ability by me to protect Hannah, but unfortunately, my estate wouldn't have reflected that. To qualify for that qualified disability trust, you have to, your disabled beneficiary, so your version of Hannah, has to qualify for the federal disability tax credit. And I'm one of the approximately 300,000 Canadians whose beneficiary doesn't so qualify. So my planning would have to be even more careful. I'd have to go using Henson Trust and other tools out there. The bottom line is I might as well rip up my will, because it didn't reflect my values, it didn't reflect what I want to do, and it didn't reflect my family. So please don't be me. Please review your will from time to time. Before we move on to this, I do want to talk about what happens if you die without a will. In other words, you die intestate. That means without a will. In Ontario, if you die without a will, the first $200,000 of your estate will go to your spouse. That's called the preferential share. And the remainder of the estate will be divided by a scheme set up by the government. So in my particular case, because I have 2 children, 1/3 of the estate will pass to Chris, that's my wife, and 2/3 will pass to my children, whether I know about them or not, whether I have good relationships with them or not, all of that sort of thing. It recognizes only the fact that I have fathered or adopted a child. And that might be what you want. You might say, yeah, you know what? A 1/3, 2/3 split with a $200,000 preferential share going to my spouse, that's about right. It's not what Chris and I want. We worked like dogs for the last 35 years to look after each other and then to look after the children. So I don't like that split. So it's important I make sure I have a will. The other thing about dying intestate is it doesn't allow you to define how people are related to you. And I'm going to tell you a story called Repeaters. It's a case from 2016. And here's what happened in that case. There was a lovely couple called Eileen and Lester Peters. And Eileen and Lester Peters, if you had met them, you would think were a nice couple. If they lived beside you, you'd say, what a lovely couple who'd been married about 44 years. You'd be wrong. Actually, sorry, you would be right on that part. You would also think they had 5 adult children. That's where you'd be wrong. Because you see, Lester Peters had 5 children. He'd been married before his marriage to Eileen. And he and his first wife had 4 children, 4 daughters. When the youngest of those daughters was about 3 or 4 months old, his first wife died. A few years later, about a year and a half later, he met Eileen, he married her, and they had that 5th child, their son. So what you really had was a gentleman with 5 children and a woman with 1 child. At any rate, Eileen raised the children. They called her mom. She took them to PTA classes, whatever, ballet classes, all those things mothers do, kiss knees, all those things that mothers do. Lester Peters died in 2008. And when he died, he left a will that left 0 to his wife. Nothing. Everything went dead. Boy, I hate Eileen. What can I do about it? I think what happened was that he knew he had a whole bunch of registered products that named Eileen as beneficiary. So those pass outside your will. And I think he also knew that he had a whole bunch of joint accounts that would pass to Eileen because joint accounts pass outside your estate. And I think he said, Eileen's well looked after. I just want to remember the 5 kids. So what little goes through my will, I'll leave to them. Unfortunately, he went bankrupt, or more correctly, the company he operated went bankrupt. He was a small business owner a couple of years before he died, and all those joint assets were securing debts of the corporation. So they were gone, completely gone. So there was nothing left for Eileen. The registered products, Eileen and Lester had lived on them very liberally, and so they pulled a lot of money out of them. So there really wasn't any money for Eileen. The 5 kids got together. They were good kids and said, what can we do for mom? It'd be humiliating for her to come and ask us for money every time she wanted to do something. And so what they decided to do was they decided to gift everything they inherited from their father to Eileen, just give it to their mother. They said that's what Dad would have wanted. That, by the way, is really bad estate planning. Because you see, the night before you die, you're deemed to sell everything you own at fair market value. All your registered products are added to income in their entirety. So if you have $100,000 in a RSP or a RIF, that's added to income in the year you die. The capital gains on any unregistered products, and cottage, etc. like that, that capital gain is added to income in the year you die. So the upshot is, in the year of your death, you're going to have a huge income inclusion for tax purposes. And so your estate is going to have to pay a big wallop of taxes. And remember, in Canada or in Ontario, the highest marginal tax rate is 53.53 for income earned over $201,000, and you'll be over that amount in the year you die. However, if you leave your estate to your spouse or in a spousal trust, there's a rollover, and that tax is only paid when your spouse actually sells the asset or when your spouse dies. So if Lester and Eileen Peters had left everything to Eileen, there would have been a lot more money for her and a lot less money for CRA. But that's not what they did. They left it through the children, and so there was a big tax payment. At any rate, Eileen Peters lived off of that money until she died in 2014. And when she died, the kids got together. Eileen had died without a will. She died intestate. And the kids got together, and the 4 daughters said to their brother, what's left in the estate? I guess we divide by 5. Remember, this had been their money. They gave it to their mother. They inherited it from their father. And their brother said, I guess we divide by 1. You guys aren't children. There's not a piece of legislation in this world that recognizes the rights of stepchildren. So therefore, everything goes to me because I'm the only child of Eileen. You guys are just stepchildren. She never adopted you. The daughter sued. And the court said, this is appalling. This is really terrible. However, this is the law. And the fact of the matter is, we're not going to write you a will after the fact because you chose not to write one while you were alive. And so to end, I guess I'll say, make sure you have a will and make sure it's up to date. Don't be Mrs. Peters and don't be me. If Eileen Peters was here on this line today, and I said to her, Eileen, how many children do you have? She would hold up 5 fingers. She raised those girls. But the law doesn't allow you to define how people are related to you unless you have a will. And that's why it's important not to die intestate. Okay, Per, let's move on to the next sin. And that is incorrectly named beneficiaries.
Keith, I'm going to stop you there for a second, and we'll just take 1 or 2 questions related to the content you just shared.
Sure. Okay, sounds great.
First of all, what would you recommend, what's the oldest you would recommend a will be dated to reflect current estate law changes?
Well, first of all, in today's day and age, I think if your will is older than 2015, you should brush it off and look at it, because that's the year that a lot of taxation of estates changed, and I don't think you should be older than that without at least looking at your will. I think a will should be reviewed about every 3 years, because that's how often your family or the law seems to change.
Okay, great.
But if it's older than 2015, pick it up today.
Yeah, make sure you review your will. And as a general rule of thumb, we say,
Yeah.
At least pull the will out of your filing cabinet drawer once every 3 years and blow the dust off of it and give it a read through and make sure it says what you thought it says, because sometimes it says something different.
Precisely.
Another question related to, you were speaking earlier about having beneficiaries or heirs with disabilities. And I believe that was, you were discussing maybe setting up Henson trusts and so forth. Is that makes sense? Can you talk a little bit about that?
Right.
Yeah. Okay.
Sure. So planning for disabled beneficiaries, there's two different types of trusts you can set up. One is that qualified disability trust. It's a creation of the federal legislation a few years ago. And as I said, the benefit of qualified disability trust is it allows for graduated tax rates, while at the same time providing for that disabled beneficiary. However, if you're like me and you have a beneficiary who doesn't qualify for that federal disability tax credit, or if there already is a trust for that disabled beneficiary, because every disabled beneficiary can only have one qualified disability trust. So if you've set one up in your will for your daughter and your ex-wife decides to set one up in their will, only one of those can be a qualified disability trust. Your beneficiary gets to elect which one. The other tool, which is used if you already have a qualified disability trust, or if you don't qualify, is a Henson trust. What happened in the Henson case was from 1986 or 87, can never remember the date. And there was a young girl named Audrey Henson, and her father, Mr. Henson, had $86,000, and that's all his money in his whole world. And he knew that if he gave Audrey the money outright, it would destroy her ability to collect income benefits under provincial schemes for disabled beneficiaries. So Mr. Henson decided, he was from Guelph, Ontario, he decided what I'm going to do is I'm going to leave everything in a trust. So in my will, I'm going to say, sell the car, sell everything, put everything into this trust. I'm creating my will. And I'm going to say in it, my daughter, Audrey, has absolutely zero right to any of the income or capital in that trust. She gets nothing unless my trustee exercises his or her discretion to give her something. And that way, Audrey could go every single time the government asked for what her income was and what her capital was, because your benefits are based on those two things. And she could say with a straight face, I have nothing. The provincial benefits group disagreed with their planning, and they refused to respect the Henson Trust. It went to the Court of Appeal, and the Court of Appeal said, no, this is a great way of providing for disabled beneficiaries. It provides benefits for them by making sure that the income you've left to them doesn't disturb their capital or income requirements under provincial schemes. There's a whole bunch of things to know about Henson Trust. We could go on for hours. One is a Henson Trust can be created while you're alive if you have a beneficiary you're worried about, or after you die in your will. That's not true of a qualified disability trust. A qualified disability trust must be created upon your death. The other thing about a Henson Trust is, remember that provincial benefits for disabled beneficiaries stop at age 65. So if you're creating Henson Trust, look at the wording and make sure that it becomes more liberal in providing for your beneficiary after age 65. Does that help at all?
It does help. And then another one was, there was a few questions where people wanted to know a little bit more about holographic wills. You'd mentioned
okay.
That, and generally speaking, I would say that we generally recommend a lawyer drafted will as opposed to a holographic will. But if you could talk a little briefly about that as well. People did have questions about that.
So, sure. Okay. A holograph will is a will that is completely in your handwriting. So a will can be formal. You can go to your lawyer and have it written up, and you have two witnesses and all the bells and whistles that goes with a formal will. However, if you don't want to do that, you can write a will completely in your handwriting. Don't buy a will kit that says this is the last will and testament of Keith Masterman, because this is the last will and testament is not in your handwriting. It has to be completely in your handwriting. It has to be signed by you. It doesn't even have to be witnessed, and it's a legally recognized will in Canada. I think that first of all, the big case on holographed wills is from 1946. It's the Saskatchewan case. What happened in that case is a gentleman was out plowing his field, as they do in Saskatchewan, and the tractor flipped over on top of him. And with his penknife, he wrote into the side of the tractor, "All for mother," and then he signed it. And the whole question was, is the tractor a will? And the courts decided, yep, that's a holographed will. It's completely in his handwriting. It's signed by him. There was another question on that because his mother was dead. He called his wife mother, and the whole question was, did he actually leave it to his mother? So these are recognized as wills. To Per's point, I don't think they're very good ideas because I think so often people don't know how to draft a will correctly. And I could go through chapter and verse, although it's 1 o'clock and we've gone through one sin, but we'll see where we get to. But I think that I could go through chapter and verse of cases where people have drafted their own will, left something out, or not understood what the words of their will means, and it's caused dissension and litigation within a family.
Okay, yeah. So
Okay.
holograph wills, if you have to do a holograph will, are best done on paper, not tractors. And then beyond that, we recommend doing a lawyer. Fair. Okay.
Yeah. There was a case. There was a case from this month, which never mind. There was a case from last month where they talked about secret trusts, and this woman died intestate. And while she was in the hospital, she called her husband over and said, "I want you to hold my asset for our niece."
Yeah.
And the court decided that that was enough to create a secret trust, and that the assets didn't go to him; they went to his niece instead. So there's a whole bunch of weird little rules. It's best just to have a will.
And then there was one last thing, and correct me if I'm wrong, legally it is possible to write a holograph codicil, which means a one-page amendment to your formal typewritten lawyer drafted will.
Yep.
And you can, it needs to be 100% in your handwriting and signed and dated and ideally witnessed. So, but that is
exactly.
Okay, great. There's a couple other questions that we'll get to. Some of them I think you're going to answer a bit later. I'm really looking forward to that. And you were ready a while ago before I introduced you to go to sin number 2. So let's do that.
Okay, let's go on and we'll see how far we get in this thing. Okay, so sin number 2 was failure to name beneficiaries correctly, and I'll cover this in a little bit less detail simply because I want to make sure we get some time together. I think it's really important when you think of your will to make sure the words in your will are defined to reflect your family. So what does children mean to you? What do nieces and nephews mean to you? So children's a word that has changed in meaning over the last several years. If I had died 5 years ago and I left my estate to my children and I didn't define what children meant in my will, or if I died intestate, so I couldn't define my will because I died without a will, the government sets out what the word child means. So if I died 5 years ago, children would be those people who I fathered during my life, the people I adopted during my life, whether I knew about them or not when I fathered them, by the way, and we're not going to get into that, and anyone I fathered within 9 months after my death, the ventre period. Today, children means anyone I fathered during my life, whether I knew about them or not, we're not going to get into that, anyone I adopted during my life, and anyone I fathered within 3 years after my death. So they've extended that period for me to father children after I die. Just like earlier, I told you the definition of parent-child has changed, and that's in the All Families Are Equal Act. So what that means is that my common law partner or my spouse can go to my executor after I die and say, you know what, part of the estate is left to children, or he died intestate, part of it goes to children. I might choose to have another child with this man through artificial insemination with DNA material he's left behind. If within 6 months after my death she makes that election, and if my estate passes to my children, then my estate is now frozen for 3 years because my will didn't define the word child. So I have to make sure when I'm looking at words like children, nieces and nephews, I have to make sure that I understand what those words mean to me and that my will defines them to reflect my family. The point about nieces and nephews is simply this. I have a brother and 2 sisters, and between the 3 of them, they have 10 children. But I also have a brother-in-law. My wife, Chris, has a brother, and he has 2 daughters, Megan and Lindsay. If I left my estate to my nieces and nephews, Megan and Lindsay would get 0 because the law only recognizes blood. And you know, Megan and Lindsay are very close to me. They came around after we got married, and I bounced them on my knee and took them tobogganing and all those things uncles do. It also plays a bit of Russian roulette, because let's assume for a minute, Chris and I both have a will that leaves everything to our nieces and nephews after everything goes to each other. So my will says all to Chris, and then her will says to our nieces and nephews, or my nieces and nephews, and my will says, and her will says the same, everything to me and then to nieces and nephews. Now we're playing Russian roulette of who dies first. Because if I die first, my assets pass to Chris, and then she leaves it to her nieces and nephews, Megan and Lindsay get 100% of the estate, because the law only recognizes blood. So when I do this, I have to make sure there's some definition of my will that says, wait a minute, nieces and nephews in my world means something different than the law recognizes. I'm going to pass it down to what happens if a charity is misnamed or merges after the date the will is drafted. So I live in Stratford, Ontario. And as I told you, I want to pass my values on and leave something to our community. So I have 2 charitable gifts in my will. Excuse me. One is to the Stratford Shakespeare Festival Theatre, because it does an awful lot of good to our community. It's the reason we're here. And the other one is to the Perth Huron United Way, because I'm a director of the United Way, and I think they do a lot of good things. What happens if rather than leaving that gift to the Stratford Shakespeare Festival Theatre, I leave it to the Festival of Stratford, Ontario? Or what if 3 years after I write it, but before I die, and I've named it correctly, so I've named it as the Stratford Shakespeare Festival Theatre, it merges with the Shaw Festival down there in Niagara-on-the-Lake and becomes the Festivals of Southern Ontario. What is the ramification on that gift? And that's what I want to talk to you about for a minute. Let's go on to the next slide. And just a reminder for you guys, before we do move on to that, of the tax advantages of a charitable gift in a will. So if you have a charitable intent, or you want to hand your values on to your children, a charitable gift in a will is a wonderful thing. I would never tell people to put a charitable gift in their will for tax purposes, but if you do have that intent, it's a great gift. It's a great place to put a charitable gift. Because as you'll see, a charitable gift in the will can be used up to 100% of the value of a charitable gift in a will can be used to write off income in the year of death. And remember, because of that inclusion, you're going to have a huge income inclusion in your year of death. And so it's a great tool to reduce income in the year you die, up to 100%. It can also be carried back 1 year to redo your private year tax returns, or move forward up to 5 years by your estate executor if he's a clever person, if there's anything left. I think when you're alive, it's only 75% can be written off against income, so there's a bump up. The other thing is you'll notice capital gains realized on donations of public securities is nil. So that means it's not even included when we do that deemed disposition on death. So if I were to have a whole bunch of shares of Royal Bank of Canada and they've had this huge increase, my executor, if he's clever, can give those to the charities, and that capital gain is not even included in income. So it's a double whammy of a gift. But that's not what I'm here to tell you about. Let's go on to the next slide and we'll talk about what happens to that gift. So what I wanted to talk to you about was the Cypre Doctrine, which is the next slide when we get there. Oh, there we go. So the Cypre Doctrine says that a gift to a charity, so remember my gift to the Stratford Festival, a gift to a charity will fail if the charity is improperly named or if the named charity ceases to exist, unless the will provides the executor a power to choose a succeeding charity which resembles the one in the will. And that's a lot of work for your executor. So let's say, and I'll tell you why, I'll give you a case. And the case I'm going to give you is called Ridge Meadows. And what happened in the Ridge Meadows case was that there was a gentleman who left his entire estate, which I think was about $2.9 million, to the Society for Retarded Children in Haney. Haney was a little town where he lived. Well, it doesn't take very long to realize there was never an organization called the Society for Retarded Children. It's just not the way we talk in Canada. So after he died, his poor executor has this gift to a charity. And 3 charities came forward and said, I think we're the organization. One was an organization that helped children. One was an organization that helped people in Haney. And one was an organization that helped people with mental disabilities. The poor executor goes, I don't know which of you is the charity that closely resembles the one in the will. I can only leave it to one. I can't divide up the money. So he went to court, and he asked the court for assistance in deciding which charity was the proper charity. But you know what? The charities and the executor were not the only people who went to court that day. They also, the second cousins of this gentleman also went there, because he didn't have a wife, he didn't have nieces and nephews or brothers and sisters. So his next of kin were these second cousins, most of whom we'd never met. And they argued, well, the side prey doctrine says unless there's a power in the will, the gift fails, and there is no power in this will. So the court said, oh, you're right. The gift fails. Second cousins get everything because it's an intestacy, and so as a result, the charities get nothing. So let's count the ways that was bad. What he wanted to do was help his community. That failed. That's the number one thing. All those tax benefits we talked about failed. So that's another thing that's bad. And I think the third thing was it became very costly because they ended up having to go to court, and that's something you should probably try and avoid. So Per, shall we move on to the next sin, or do you want to talk for a few minutes? Or
I don't think there's a particular question on charitable. Oh, there's one question here. A client, or sorry, one of the attendees has an up-to-date will, and all of her money is going to charity. Now, as she's wondering about the capital gains on her donated stocks, must it be paid immediately, or before the estate can use the charitable donation receipts to counteract the capital gains? How does that work?
I believe that on her, I'd have to look that up, but I believe on her final tax return, she can take the gift back on her final tax return. So I don't think she has to claim the deemed disposition on her final tax return.
Right.
I'd have to look that up. I will.
That jives with my understanding as well. You'll show the capital gain, and it'll be offset by the donation. So you show an in, but you don't actually have to move the money in your bank account first. So
exactly. Okay.
Okay, great. All right, sin number 3. We do have some other questions that I'm storing up for a little bit later, just so you know. So
okay. Do an appropriate choice of executor. So the executor is the person you name in your will who's going to have the legal responsibility to administer your estate. It's a lot of work. I told you I wasn't going to tell you all the chores an executor has to do, but I know I have a checklist online, which we can send you if you're really interested, which I think has about 70 different duties of an executor. So they have to, pay your taxes, all sorts of stuff they have to do, call in your assets. What I wanted to talk to you guys about was the conversation I had with my son, Jack, when I named him as my executor. For a whole bunch of reasons, Jack's the right choice. But I want to talk to you about that conversation, because you should have that conversation with your own executors and talk about what made me concerned when I named a family member, someone I happen to love, as my executor. So my executor is more or less 4 people in one person. My executor is a little bit of an accountant, because he's going to have to deal with the accountants and CRA on my estate. And he's also going to have to keep the records of my estate, the accounts of my estate, in what's called a triple ledger form. And we'll talk about why he has to do that in a couple minutes. The second person he's a bit of a lawyer. So my son's going to have to make a whole bunch of decisions that could have a legal consequence and have personal liability on his behalf if he makes the wrong decision. And the law is constantly evolving. So the decisions Jack makes, he's going to have to be very careful about, and he can't always go back to the estate lawyer because that will cost him a fortune. And I'm going to give you an example, if you'll allow me, of a case that was from last year. And the reason I want to give you this case is because I would have made the wrong decision after 34 years in the industry, and I would have been personally liable for $150,000. But this is the type of decisions my executor is going to have to make. And this is called Texera and Markov. And it involves an elderly woman named Maria Markov. Maria Markov lived beside Anton Texera, and he was the most wonderful neighbor in the world. He would come over and he would mow the lawn for her, and he would do chores around the house. He would take her to the doctor. He would help her go to the grocery store. When she needed a lift, there he was with his car. He was wonderful. Maria found out she was dying, and she went to her lawyer and she said, I want to do 2 things. One, I want to leave $150,000 in my will to Anton to thank him for being such a great neighbor. Boom, he can get $150,000. Let's redo the will. And secondly, I want to go home today and I want to give him a check for $150,000 to thank him. So he's going to get $300,000 from me. So they amended the will, and Maria signed it. She went home, and the next time she saw Anton, she said, Anton, I want to give you this check for $150,000 to thank you. Now, Anton did not do what a lot of you would do, which is to say, no, Maria, I do this because I'm a nice guy. You just keep your money. I don't want it. He said, thanks, and grabbed the check and stuffed it into his pocket and hurried down to the bank. When he got to the bank teller told him, there's not enough money in Maria's account. This is NSF. Can't cash it. However, she said, Maria comes in every Thursday. So if you wait till Thursday afternoon, there will be enough money in this account, because Maria rearranges money in her account. She's got tons of accounts and tons of money. She just doesn't have enough in the right account at the moment. I realize that the bank teller breached her privacy. We can talk about that some other time. So Anton took his check and went home. Maria did not go to the bank on Thursday. She died instead. So Anton is left with a check for $150,000. He went to the executor and he said, oh, I've got a check here for $150,000. Here it is. I want you to honor it. I would have paid it, because in all the years I've done estate administration, I've been told that an outstanding check is a liability of the estate, and the estate pays its liabilities. However, the executor in the Markov case said, no, you know what? You can sue us for the money. We're not going to pay it. And that's exactly what Anton did. And Anton lost. The court said, usually Keith would have been right that it's an outstanding liability, you pay it. But they said, this is a gift, and gifts are very special in Canada. And for there to be a gift, there has to be an intention to give. Well, she gave me a check for $150,000. An intention to receive, well, I stuffed it in my pocket. And there has to be actual delivery. And the court said, a check is not delivery. The cashing of the check is delivery. And since the check wasn't cashed, there is no gift, and so there's no liability. I only raise it to say these are the sort of issues my executor is going to have to deal with, and I had to talk to Jack about his personal liability. Jack's also going to be a bit of a general contractor, because Jack's going to have to go through our house and get rid of all the stuff we've accumulated, and boy, we've accumulated a lot of stuff. You know, Chris and I don't throw out anything. If there's a piece of paper with a line that Hannah said was a boat that she drew in school, it's up in that attic somewhere, just up that stairway. We're going to tell Jack, at a time when you're grieving our loss, because he's going to miss us, hopefully, and keep our fingers crossed on that one, I want you to go through this house, and I want you to throw out your childhood. But that's what we're asking him to do. At a time when he's very sensitive, very fragile, that's what we're going to ask him to do. And the last thing Jack's going to be is a psychologist. Because at a time when the family's rupturing because they've lost the patriarch or the matriarch in Chris's case, we're going to ask him to put it back together again, because everyone will be grieving in different ways. And that's going to be very hard in my family, because remember, there's a trust from my daughter, and Jack's the trustee of that trust. So not only is he going to be dealing with people's initial reaction, but for years he's going to have to deal with his sister. I've changed him from being babysitter and babysat, as opposed to brother and sister. So those are some of the things I wanted to talk to them about. You can skip slides, because these don't really have much to do with what we're talking about today, so we'll just go through them. A couple of other things I wanted to talk to Jack about are, I have to keep an eye on when I'm thinking about naming the right executor, is where does my executor live? You see, the law in Ontario says that if my executor is a resident of the Commonwealth of the United Kingdom, they can administer my estate without posting a bond. But if they're not a resident of the Commonwealth, they have to go to a bond company, so an insurance company, and buy a bond. That's money out of their pocket, and they have to renew it every year as the estate is administered. So Jack and Kelsey, that's my daughter-in-law, they live in London, Ontario. So that's part of the Commonwealth, no problem at all. But kids move all the time, so I have to keep watching my will to make sure I don't have a non-resident beneficiary, non-registered executor. Non-resident executor. If Jack and Kelsey next year move to New Zealand, still don't have a problem. That's part of the Commonwealth. But if they decide I'm going to move someplace more exotic than New Zealand and move to Detroit, Michigan, just down the street, I have a problem, because I'm a non-resident executor. The other problem I have is that your estate for tax purposes, a trust for tax purposes, remember I have that trust for Hannah, and also an estate as a trust. The estate for tax purposes is where dominant management and control reside. So the residency of a trust for tax purposes is where dominant management and control reside. If my executor is a non-resident, chances are really good my estate and my trust will be taxed as a non-resident American resident. The other thing that I have to worry about is the expenses of the estate and how will they affect Jack. So I told you about Jack's triple ledger system. He has to keep his estate, he has to keep everything in. That's really important because at the end of the day, every one of my executors can challenge every one of the expenses he pays. You see, when you do estate administration, I'm sure you've all done some of this, the first thing you do is you open a bank account called the estate of, in my case, Keith Masterman. And then you start moving all my money from my registered accounts, from my non-registered accounts, my bank accounts, into that account. And then you start paying my debts. And it looks to you like you are paying the debts of the deceased, of me, Keith Masterman. That's a legal fiction. The executor is paying their expenses, and they're then reimbursing themselves from the estate. What Jack should do is he should be paying out of his own pocket and then reimbursing himself with every expense he pays. But nobody does that because that's silly. But at the end of the day, every beneficiary, my son, my daughter, my wife, those grandchildren, the charities, they all have the right to ask Jack to prove every one of his accounts and every one of his fees in court. It's called a passing of accounts. So Hannah could say, you know what, I think you paid too much. I think you paid the lawyer too much who helped you. I think you paid the accountant too much. And they have the right to go to court, and Jack has to prove his accounts. And if the court says, yeah, you know what, we agree with Hannah, you paid the lawyer way too much, it's not that the lawyer doesn't get paid, it's that Jack doesn't get reimbursed. So I have to worry about how that's going to affect the family and have him understand that there's some liability there as well. And the last thing I think I'll talk about with executors is the estate information return. A few years ago in Ontario, the Ontario government looked at estates and said, you know what, we're not collecting sufficient probate fees. And we'll talk about probate in a minute. And what they said the problem was twofold. One, they said people weren't disclosing all assets that go through the estate. So think of me, for instance. I've got some paintings here on my wall. I don't set them out in my probate application. I just say to Jack, you know what, give them to whoever wants them, because he can deal with them without probate. And the court said, well, then we're losing probate fees because you're not setting them out in your probate application. And the other thing is, when you do your probate application, all you have to do is use best efforts to value the estate. It doesn't have to be accurate. So best efforts would include, again, using that piece of paper as my demo, would include that Jack could go to the last notice of assessment of my house and say it's worth $350,000. Remember, I'm not in Toronto, I'm out here in Stratford, so we're worth a lot less. And that's fine. And the government said, but you know what? We think people are undervaluing those assets. We think that house is probably worth more. So they started a new system. Within 180 days of Jack receiving probate, he has to file with the Ministry of Finance what's called an estate information return. And in that return, he has to guarantee that every asset that passes through my estate is listed there. And he also has to guarantee that every value is correct. So estate administration just got more expensive, because he can't pick up the notice of assessment and say, well, the last notice of assessment said 350. He now has to go out and have it valued by a professional evaluator, because he has to prove those values. Once the estate information return is filed with the Ministry of Finance, they have the right to audit his account. They're not going to audit every account. They're going to cherry pick. But if they choose to audit his account and they say, you know what, Jack, we think this valuation is incorrect, or we don't think you included the boat, or whatever it might be, and they decide that something is wrong, the penalty to my executor is 2 times the probate fees that are owing, plus $1,000, plus up to 2 years in jail for my executor and any professional, such as a financial planner, who assisted in the valuation of the assets. So I have to be careful of that. Now, I don't believe Jack's going to go to jail because he underestimated my coin collection, but the liability's there and I have to worry about it. I think that's all I wanted to say about executors at the moment, so we can skip ahead to slide or two. Okay, here we are. Oh, one more. Let's go.
No, I'm going to, unfortunately, I'm going to ask you to say 1 or 2 more things about executors.
Okay.
So a question came through, and here Terry's asking, since the duties of an executor are complex and most of us are not trained in this area, and then I'll paraphrase, what should we do? And often, on my side, I know that we recommend either you find somebody in your a friend or family group that is an accountant or a lawyer that can help you. And
Yep.
barring that, unfortunately, your financial advisor is legally not allowed to help you with that. But we often then recommend looking at a corporate executor. And
Mhm.
so maybe, Keith, you could take a couple of minutes and just talk briefly about corporate executors.
For sure. So a corporate executor is a tool that's available from every bank. Well, actually, every trust company in Canada likely has a corporate executor function. So you don't have to name an individual as your executor. You can name a professional trust company to act as your executor. That's called a professional trustee, a professional executor. They will take on the burden of responsibility of administering your estate. You can even do fancy things by having a professional executor, say, I don't know, Royal Bank Trust Company act as the executor, and then you can also name a family member, just so that the family member has to agree to everything, has to go, I don't think Dad would have wanted that. I actually walked on the beach with him, you never did, and it gives that personal touch. The professional executor, the benefits of it are numerous. One, at a time when your family is busy grieving, an awful lot of what I talked about with Jackie, Jack, sorry, I should probably call him by his grown-up name, that he's grown up, but an awful lot of what will happen when Jack is grieving my loss and he's got all this work to do, someone else is doing it. It takes that away and lets the family recuperate and come back together again. You also know it's going to be done to the letter of the law, and you know that if it's not done to the letter of the law, someone with incredibly deep pockets, the trust company, is going to be on the hook for the administration. So I think that's another big benefit of it. It also gives my it also gives my family the ability to get professional reporting, etc. on it. So I think it's a great option. If you don't name a professional executor, so you've named your son, so I've named Jack, and at the end of the day, Jack says, I just can't do this. Jack has the right to go and hire a trust company as his agent and say, you know what, you do all the work. I'll still be here to sign off and everything, but you do all the work, and it does the same protection for Jack. The disadvantages of a professional executor, in my humble opinion, are one, they're going to administer your estate to the letter of the law. So you've got to really be careful about what your will says. If your will says all paintings will be sold, they will sell all paintings. There won't be, well, we'll just give it to the family because everyone's agreeing to it. That's not going to happen. They administer to the letter of the law. The second disadvantage is obviously there's a fee involved with administering an estate. Every executor can charge a fee. The rough guideline in Ontario is an executor can charge up to 5%. That's a very rough guideline. There's a whole bunch of rules. But the professional executor will be charging a fee, whereas Jack might not bother to charge a fee on the estate. So those are sort of a bit of the pluses and minuses of a professional executor.
Thanks, Keith.
No problem.
That's really helpful. Let's see, let me get to the, there we go. Did it.
Okay. So yeah, so I realized that we're running out of our time together, and we're at number 4, which is not great. But I do want to talk about.
Keith, we've got probably at least another half an hour or more.
Oh, so. Perfect! That's fantastic. Sorry, I don't know why I thought it was the.
Don't feel stressed. So
I don't know why I thought I was going to get the hook in a few minutes, but there you go. So what I wanted to talk to you about for a few minutes was ignoring assets with sentimental value. And it's always been my belief that people don't fight over things. They fight over, they don't fight over money. They fight over things, because emotions are raw when you pass away, and suddenly you're going to have a whole bunch of people fighting over grandma's watch, grandpa's coin collection, all of those sort of things. A few years ago, I was up in Ottawa, and I was doing a presentation, and we got talking about sentimental value assets. And a lady put up her hand. This was in a room of about 300 people or so. She put up her hand and she goes, boy, do I have a terrible story for you. And this is the story she told. She said, my aunt died a couple of years ago. She was 92 years old. And she said, when my aunt died, I was to receive her second best mattress. And the following Christmas, I was at my niece's house, and I went up to her spare bedroom and I peeled the covers back, and I know that was the second best mattress, and I probably got a different mattress. I've stopped speaking to my family over this. Now, regardless of the fact of whether you want a 92-year-old's mattress or not, no, but I think what it really drew home to me was people fight over the oddest things. And it's important when you do your estate plan to talk about sentimental value assets. I'm sure you guys remember Robin Williams. He died several years ago. He was a comedian. And when he died, he left an estate of $100 million. That's a lot of money. And he left every penny of his $100 million to his three children from his first and second marriages. I can't remember whether it was two children from his first marriage and one from his second or vice versa, but he left all his money to those people. Sorry, I lost my train because I saw a question come up. But anyway, so he left it all to his children. What he said to his wife, he was married for the third time. So what he said to the present Mrs. Williams is, "You get two things. Everything we accumulated from the date we said I do forward, you get, and you get the right to stay in my house for the rest of your life. You have to pay all the expenses, but you get to stay in it." Shortly after Robin Williams died, his wife came to his children and said, "I can't afford the house. I'm not a very wealthy woman. You guys are, memory serves, but I'm not a very wealthy woman. So I can't afford the upkeep of the house. What I'd like to do is we're not going to, even though they eventually get the house." And they all went off to mediation. That issue was solved pretty fast in the mediation. What was it that Robin Williams' family fought about for another 9 months? Mrs. Williams also said, "I would also like the tuxedo my husband wore to our wedding." And the children said, "You get everything he accumulated after you said I do. He had that before, not a chance." People fight over these sentimental value assets all the time, and it's important you deal with them. Before we leave this, I do want to talk about digital assets, because I'll bet you if your will is deficient in one place, it's digital asset planning, because it's important you have clauses in your will talking about digital assets. Digital assets are all those things that float around in cyberspace. It's your Loblaws card, it's your Bitcoin account, it's your Air Miles points, it's all of those things. And it's important you deal with those things because for three reasons. One, those things have value. You know, the average Canadian, I think, has about $2,000 or $3,000 in online assets, on digital assets. And it's bad estate planning to leave money on the table. And a lot of you probably have more assets and digital assets than I do, because I only have a Loblaws card and I can't find it. So probably you guys I bring the total down. The other reason it's important are those are the sentimental value assets of tomorrow. If you came to my house here and you went into the spare closet, that bedroom over there, you would see photo album after photo album after photo album, and then you'd see a big box of photos when we got tired of putting photos in albums. If you go to Jack's house, you don't see that. Everything's online. Everything's on Facebook or wherever. He doesn't have photo albums all over the house because the way we keep our records has changed. You know, one of the greatest ironies of my son's generation is they write back and forth more than any generation in history, and they will leave less permanent record because it's all digital, it's all online, it's all on Facebook or whatever else there is. And the third reason it's important to deal with your digital assets, because I'll tell you, going back to that second one, if something, God forbid, should happen to my son or daughter, I would want every word they put online, and I would want every photo they've ever put online, because that's all I'd have. Those are my sentimental value assets. Third reason it's important is because the incidences of identity theft are massive after you stop monitoring your online accounts, and you stop monitoring them almost immediately upon death. So it's important you've given your executor the power to get rid of those accounts. So I'm going to tell you a couple stories, and I'm going to talk to you about the Daftari and the Stassen decisions. These are American decisions, but I'm going to bring it to Canada. Miss Daftari was a beautiful, beautiful, beautiful woman. She was 23 years old the day she died. And the reason I mention how pretty she was is because she had just won the Face of Asia contest. And it was believed her modeling career was going to go like that, and she was going to be one of the top models in the entire world. Her career was set. Shortly before she died, she got married. Or she thought she got married. It turned out her husband already had a wife and a couple kids, but she went through a form of marriage. Immediately after the marriage, her conversations with her girlfriends changed. She started talking about sexual abuse. She started talking about psychological abuse. She started talking about physical abuse. She was terrified of her husband. She also believed in her heart of hearts that there was a stalker living in her apartment building, and she was terrified of that man. One day, she was in her apartment. She was packing because she decided to leave her husband. And so she was packing up a suitcase in her bedroom. And for some unknown reason, she went out onto her balcony and fell off the balcony to a painful death. Her family was convinced she'd been murdered. The Stassen decision is a fairly similar case. Young Mr. Stassen was a university student. He had left the country where he was raised and he was living in the city. I teach university. And young Mr. Stassen would have been one of those kids that would be on a sort of a watch list by the university. When you assign group assignments, nobody chose him. When they all came in Monday morning and talked about the fun they had on the weekend, he wasn't talking to anyone. Young Mr. Stassen hanged himself one night and didn't leave a suicide note. What are the common elements between the Stassen family and the Daftari family? Well, both of them contacted every one of those online providers, those digital providers, Facebook, etc., and said, we want access to every single thing our kid put online. We got to have it. Mrs. Stassen said, this is important for my mental health. Daftari said, we want to see what was going on in her life because we think someone killed her. And what was the answer that all those online providers said? Not a chance. We do not cooperate with families unless there's a specific clause in your will authorizing the digital accounts to deal with them. And in both those cases, the client died intestate. And why is that important? Well, the online providers say, you're asking us to breach privacy legislation. We're a company that deals all over the world. And because you're asking us to deal with, to hand information over without a direction, either a direction entered while you were alive, because you can do that, or without a direction in the will, we will not cooperate. The family sued, and they actually won. They won in the trial court, but they went on to the Court of Appeal in the Stassen decision, and the Court of Appeal said, we can't ask a company to breach privacy. You have to have that direction in your will. Bring it to Canada. There was a case in Canada called the Henry decision last year, and you probably read about this decision because it's just appalling. It was a woman up in Ottawa, Ontario. Her name was Maureen Henry, and she had a son named Dovey. He was, I think, in his early 20s. And he disappeared, gone. And nobody knew where he went. Investigations were held for a very brief time, and then everyone sort of lost interest except Maureen. She never lost interest in what had happened to her son. And about 2 years after his death, she's surfing the net and she sees a note saying the body of a black boy has been discovered in Toronto's harbor. And she says to herself, oh my God, it's Dovey. I just know it's Dovey. And she was right. They were able to prove it was Dovey. So she started contacting all those online providers and saying, I need access to every single thing my son put online. It's all I have left. The online providers refused. Maureen Henry sued and she won. The Ontario court up in Ottawa said, you know what, we don't care about this privacy thing. We're going to order you to disclose all the information. She has not received one scrap of paper from any of those companies because they've all said, we're international companies. You go down and get orders from the United States courts and then we'll talk to you. She's not a very wealthy woman and that's not going to happen. So it's so important when you look at your digital assets to have those directions in your will, because otherwise you're leaving assets on the table and you're not allowing your executor to deal with sentimental value assets. Okay, let's move on to the next thing unless people want to talk about sentimental value assets.
Okay. We have questions on the next couple of items coming up,
okay.
So I'll address some of them and then I'll share the questions with you.
Okay. So do you want me to just go on? Okay, great, thanks. So the next thing I wanted to talk to you about is lack of care and registered product designations. And this is a very, very hot topic in Ontario right now because of the Kalmuski decision that was released in June by the Ontario court. It is not being appealed, so it's good law in Ontario right now. So registered products, your RIFs and your RSPs, etc., those are wonderful, wonderful things from an estate planning point of view. And they're wonderful things because you can name a beneficiary in the product itself, and the asset will pass to that beneficiary and not go through your estate, and you avoid probate. It's also a wonderful, wonderful thing because it gets money immediately into your family's hands. I have administered way too many estates where someone has said, Mom needs money from Dad's estate because she needs to pay for groceries and stuff. And he said, well, everything was in Dad's name. It's all frozen until we receive probate, so she can't have any of the money. And that's a bad thing for a beneficiary. So registered products get money immediately into your family's hands at a time when they should be grieving your loss and not worrying about how they're going to buy dinner. However, as I said, there was a case in Ontario in June, And there was a case in Manitoba and Alberta and British Columbia now. And those cases have put a little warning cry in place about beneficiary designations. I'll tell you about well, maybe we can do the Ontario one. In Ontario, there was a case where a gentleman, I believe his name was Henry Kalmuski, left all his estate to, oh, sorry, he didn't leave all his estate. He named everything in his registered accounts. He named his son Randy as the beneficiary of all his registered accounts. So right on the beneficiary designation, he said, Randy gets it all. He put his bank accounts in joint name with Randy. So Randy gets all of those things too. And then he died. He had another son. His other son's name was Gary. I might have the boys mixed up. I think I do. But at any rate, Gary got nothing. In fact, he wasn't even a beneficiary in the will because the will goes to Mr. Kalmuski's grandchildren. So Gary started an action and he said, you know, even though Randy was named the beneficiary of these RIFs and all these registered accounts and all these joint bank accounts, I think that Dad really wanted me to have a slice of the action and really intended these to be shared with me. And that in effect, Randy's only holding the assets in trust and has to divide them up between me. And the interesting thing about the court is the court said, yeah, the starting point with joint accounts and with registered accounts is that if there is a beneficiary designation which benefits one member of a group in the family over everyone else in the group, so in this case, Randy's benefited over Gary, then the law is that Randy is holding them in trust for the entire family, in trust for the estate, and they must pass through in accordance with the will, regardless whether they're a registered account or a joint account. And it's now up to Randy to lead evidence to prove to us that Dad really, really intended these monies to go to him. Otherwise, he's only a trustee and he has to return them all to the estate. Randy's tried to lead some evidence. It was kind of interesting evidence. I won't go into all the detail. But one of the things was the conversations with the financial advisor. Financial advisor had some notes that seemed to suggest that this was intended. And also, if you looked at the registered account documentation, it said right on it, this is intended to pass to our son. The court said, we're not really impressed by the registered documentation because we have no evidence that he really understood what that said. So we're not going to count on that. What we want to do is hear evidence by people who can actually swear to what Dad intended. And we don't think that the evidence you, Randy, have led proves to us that your father really intended you to have this money. So everything gets divided up in accordance with your estate. So the problem with registered accounts and registered beneficiary designations is they're a wonderful, wonderful tool, but you have to make sure that you leave sufficient evidence behind of what your intention was. Because the courts now will presume that the beneficiary is holding it for your estate and will return it to your estate unless there's sufficient evidence to prove they meant something else. So that is number 5. Shall we move on to number 6? Or
Yeah, Keith.
where do you want to talk for a while?
Yeah, one question that typically comes up, and it came up last time we did this presentation as well, and it doesn't necessarily relate to registered products, but it relates to when you have a joint account with your, let's say you put a Jack on a joint account with Jack, and you did that because you intended that Jack would then share that money with everybody else, and you're trying to avoid probates and capital gains tax, etc. Talk a little bit about the risk, the pros and cons. There's a lot of pitfalls with that, as far as I understand, and you know, it can be
for sure
by one beneficiary and another way by another, and often lawsuits and arguments ensue.
So let's go back in time for a minute, and let's go back to, I think it was, I don't know, 1997, I think, when the Supreme Court of Canada heard the Pecor decision. And what happened in Pecor was that there was a man named Edwin Hughes, and Edwin Hughes had 3 daughters. But good news for us, because you're all getting tired of my stories, he only liked one of them. He only liked Paula. So Edwin Hughes did 2 things. He went into his financial advisor, and he said to his financial advisor, I want to name Paula, my daughter Paula, I want to transfer my investment account, it's a non-registered account, holding $950,000. I want to name Paula as the joint owner of it. So everything's going to be in joint name with Paula. He then wrote a will that left half of his estate to Paula and half of his estate to Paula's husband, Michael. He then died, and nobody cared. Because whether Paula gets all the money because she's the joint holder, because the way joint accounts work is that if I name someone as my joint owner, these are not tenancies in common, but joint accounts. If I name someone as my joint owner, I don't have the right to leave the money to someone else. They receive it automatically, and it bypasses my estate. Whether she received it because she was the joint owner of the account, because the financial advisor registered it that way, or whether she receives it because it goes through her estate, who cares? Michael and Paula got 100% of the money. They cared 3 years later because Michael divorced Paula. And Michael was clever. And he said, if the money is left in a jointure, so if it was a joint account and she received it under a jointure, it's a gift. And the law in Ontario states that I can't claim against a gift under Section 2 of the Family Law Act, so I don't get a nickel of the $950. But if Paula was actually holding it for the estate, then I get half of that money because I'm the beneficiary of the estate. And he sued and he sued and he sued, and we went up to the Supreme Court of Canada. And the Supreme Court of Canada said, when there's a joint account with a child, whether they're an adult child, if there's a gift with an adult child, if there's a joint account with an adult child, the presumption in Canada is that the child receives it, but is holding it in trust for the estate and must distribute it in accordance with the estate, unless that child can lead evidence to establish that the deceased meant it to be a true jointure, in which case they get it. In 2015, just to finish our story, there was a case in Ontario called Sowden. It's a Court of Appeal decision. And Sowden brought forth a third situation. So we have the situation where there's lots of evidence that Dad really intended Paula to have it. There's the number one presumption that Paula holds it, but she's got to divide it up with the estate. And then there's the Sowden case. Mr. Sowden had 5 children, and he had $780,000. And he put the $780,000 in a joint name with his oldest 2 boys. He then died. When we read his will, he didn't leave any money to any of his children. He had 5 children. He left it all to the Jehovah's Witnesses because he was a witness. And so after he died, the oldest 2 boys said, well, we think this is one of those true jointures where Dad really meant us to have it, so we're going to keep it. And then we had the Jehovah's Witnesses saying, no, we think we get the $780,000 because we're the beneficiaries. And he had the other 3 kids go, what? Regardless of what way you go, we get 0, and Dad liked us. And the Court of Appeal said, oh, sorry, there's a third situation which we forgot to mention to you. And that is, there are going to be times when money's held in joint name with someone, and we decide based on what we think is fair that the money wasn't held in trust for someone else. In this case, we think it was held in trust for all 5 kids. So all 5 get it, and the Jehovah's Witnesses get 0. So joint accounts are very, very complex because you've got to leave tons of evidence of what you intended. The other reason they're difficult is because if it's a true joint account, so I put it in Jack's name and I really intend him to receive it, there's a tax liability today. When I put it in joint name, if there's a capital gain on that registered account, I have to account for half that capital gain when I transfer it to Jackie. If I transfer a house into joint name with Jack, I might well have destroyed his ability to have a principal residence. So I have to be very, very, very careful and understand all the rules of this. The other issue, of course, is that if Jack and Kelsey get divorced, that asset is his asset for distribution purposes. And the other problem is if Jack has a huge tax liability or debt, he's a gambler or something, now I've put it in joint name and he'll be able to receive it. So there's a whole bunch of downsides to joint accounts. It should never be done out of hand. It can also destroy family harmony. You know, if I put my money in joint name with Jack and he said, you know what, I think Dad really meant me to keep it, I know a daughter who's going to be really upset. So there goes. That help with that one?
Yeah, and so what I get from that basically is to document some more what your intentions are, so that
for sure, you know
what you want actually happens.
Since the Kalmusky
one-page signed letter between yourselves and a witness.
Yeah, I mean, there's 2 things. One, since the Kalmusky decision, some lawyers are recommending that before you do a beneficiary designation, you go see your lawyer. I think that's a little overkill. I think it's sufficient if you lead lots of evidence. The court in Pecor set out 6 categories of evidence they will look at when they decide what type of joint account it is. And the first thing they said was the financial advisor must always be the first witness at the trial, because we want to see their notes and records. So from your point of view, make sure your notes and records are up to date and good too, because not only would they be looking at what your client set out, but they're going to look at yours. And the reason they have to look at both, even if your client sent this thing out that says, I really want Jack to receive this, is the court said we still have to be satisfied that that wasn't done with undue influence and duress. So we have to see the independent witnesses' records, and that's you.
Yeah, okay, there you go. Well, that's
okay.
All right. Sin number 6.
Oh my gosh, yeah, we're not flying through these. Inappropriate use of probate minimization tools. So we talked about probate. It's that tax that's payable on your estate to get what's called the certificate of estate trustee. I want my son to get probate because it protects someone I love, my son. If Jack administers my estate and he doesn't get probate, because it's not mandatory, if you can deal with all the assets, you can convince every bank not to request probate, you can administer an estate without probate. However, if Jack administers the estate without probate, and later there's a question about the validity of my will, someone says I married subsequently, someone says there was undue influence, I didn't sign it correctly, whatever there is, Jack becomes an executor de son tort, which simply means he must complete the administration of my estate. He will still be liable if he does anything wrong, but he can never ever be reimbursed for any expenses, and he can never ever be paid a fee. If he became an executor de son tort, he would have been protected. So it's important to get probate, but as we'll see in the next couple slides, it's, wow, that's weird. Go on to the next one. We sort of covered that off. It's expensive. So you can see here that the fee for acting as an estate, the fee the province charges is 1.5% of all the assets over the first $50,000. The first $50,000 is a freebie. So if you have an estate with $2 million in it, remember it's going to be paid on your house, your cottage, all your investments. So it's quite possible to get up to 2 million quite quickly. It's 1.5% on the 1,950,000 because the first 50 is free, and that's $29,250. That's a lot of money just to protect Jack from becoming an executor de son tort. And so the courts have, so there's an awful lot of schemes to minimize the assets going through my estate, because it's only attracted by assets going through my estate. So maybe if we move on to the next slide, I can talk about some of those. We already talked about named beneficiaries on RIFs and locked-in accounts and beneficiaries of insurance contracts. Be careful of the Kalmusky and the Morrison doctrine. Make sure you leave sufficient evidence behind about what you want. Both products have the benefit of a named beneficiary, and that therefore the named beneficiary will receive the money. The tax liability is still on the estate, but at least the assets will pass to that named beneficiary. But remember, Morrison, leave sufficient evidence of what you wanted. Jointly owned assets, I think we already talked about those as well. Be very, very careful with the control issues, the creditor issues, and also that you've documented really carefully what type of joint account it is. Is it a joint account where the beneficiary is really receiving the funds? Is it being held in trust, or is it some other situation like the Sowden thing? Gifting before death. If you give away your assets before you die, there's nothing that can attract probate. It's gone. But be very careful when you gift assets before you die. Remember 2 things. One, it's a gift to you, but CRA quite often sees it as a transfer at fair market value. So if I gifted my cottage to my 2 children today, don't have a cottage, but we're increasing my my assets a little bit here. If I gifted my cottage to my children today, CRA says, well, Keith, you actually sold it at fair market value, and you're going to have to include the taxes now. So I'm avoiding probate, but I'm incurring a tax today. The other thing is I better make sure my children love me a lot, because I'm giving control up of an asset. So, you know, let's do the cottage example. I transfer it to Jack, and that's fine for a few years, and then Jack's remarried to someone other than Kelsey, who doesn't have the history of the family. And his new wife says, you know, I'm getting really tired of your father coming up to our cottage. And Jack says, okay, yeah, I'll tell him to stop coming up. I've lost control over that asset. So be very careful of the taxes and the loss of control over gifting. Transferring assets to a nearby trust, that could be a whole presentation. There are 2 special trusts in Ontario, in Canada, called an alter ego and a joint partner trust. They are only available to Canadians over the age of 65, but they can be used as will substitutes. I have articles talking about the advantages and disadvantages of them. The main advantage is it avoids probate, but there are some disadvantages of them. And again, given that it's like 5 to 2 or something like that, I suspect we can't do that. Multiple wills. In British Columbia and in Ontario, you can have more than one will, as long as you're careful not to revoke one will with the other. So a lot of Canadians in those two provinces who have expensive art collections or who have private interests in business will enter a second will, say, use this will, my primary will, to transfer assets that are subject to, that where probate is required to administer. But use the second will to transfer assets that don't require probate to administer them. And those assets include private company shares, because the executor can have himself declared a director of the corporation, and he can transfer the shares without probate, because he doesn't have to, he's not going to require probate of himself. So by having dual wills, if you have large estates with assets that don't need probate, it protects those assets, it transfers those assets and minimizes the values of the assets that are going to go through probate. So let's move on to the very last thing, if we still have anyone with us, and that is understanding the words and powers used in your will. I think it's so incredibly important to understand what your will says. And if you don't understand what the words say, read the whole thing. And if you don't understand them, ask your lawyer. If your lawyer can't explain them, tell your lawyer to go read a textbook and then come back and explain them. Because every word in that will is important. And I'll give you an example. If I can have like 3 more minutes of your time or a minute and a half more of your time. I years and years ago worked on an estate called or on a trust called the Vicky Claycorn Trust. It's a public trust. And what had happened was a woman named Vicky Claycorn was a school teacher in a school district pretty close to where I am right now. I live in Stratford. And Vicky saw an awful lot of need in her school zone. And so what she decided to do, she didn't have any family. Well, she had one brother named Reuben, but he was like 70. So what she decided to do was she decided to, in her will, create a trust. And she said, I want you to sell every single thing I own, put it all into this trust. And every year I want you to invest the trust, give it to someone like Per Homer here, and have it invested. And every single year, the income that's generated by that trust, what he's managed to create in that trust, I want you to pay it to children in need in my school district, because I see such need as a school teacher. And she was a saint. That trust has done amazing things. It's gotten kids out of violent situations. It's got emergency food to kids, right through to getting braces for kids. We bought a lock for some kid who couldn't afford a lock for his locker. I'm not the only one who thought she was a saint. Her brother Reuben thought so too. Remember I mentioned she had that brother. He was the principal at the high school. And he said, I really like what Vicky did, and I want to take off where Vicky left off. So what he did was he said, sell everything in my estate, put it in a trust, give it to an investment advisor. And then what I want you to do is I want you to take the income created every year and give it to students going to university from my school district. We went to court 4 times to try and correct that error. Do you see the error? Give it to students going to university from my school district. Would it surprise you to know that 86% of the students in that school district go to community college? If they go on, they don't go to university? Would it surprise you to know that most students don't go to either? They go to apprenticeship programs. But because he used the word university, we were completely prevented from giving any money to those people. We couldn't possibly give up money in that trust. So he never sat down with someone over a drink or over coffee or whatever you want to sit down and say, what does that word mean? Is that really the word I mean to put in my will? He just trusted that all the words were correct. I could give you a whole bunch of other examples, but I think that's where I'm going to leave it off and just say, in conclusion for today, pull out your will. Think about the things we've talked about today. Think about digital assets. Think about, do you understand what the words of your will mean? Think about how you define your beneficiaries. Think about whether you want charitable gifts in your will. And read your will and say, does it do all of those things? And if it doesn't, it might be time to revisit your will. So with that, I'll turn it back to you.
Thanks for that, Keith. So I really appreciate the time you've taken to go through all this. We still have a number of questions, and I am hoping to kind of go through those with you if possible.
Sure.
And now just one second here, let me just fix something here. All right. And what we've got here is a number of different things. So the first one is people were wondering about, can you name two or more of your children co-executors? And could you talk, briefly about that?
Yeah, you can have as many executors as you want. You can have co-executors. The problem with co-executors is all executors must agree on every step. And so the more you have, especially given how people are going to be upset and dealing with grief and all that, the more executors you have, the less likely it is that they're all going to agree on every single one of the steps. So you're setting yourself up to having a fight between your children, I think, if you have too many of them. I think if you have two, okay, it's understandable. But if you have 5 or 6 children, I think you're setting yourself up to administrative delay, because everyone's got to be involved in every decision, and eventual disagreement within your family.
Okay, and then could you talk a little bit about, you talked a little bit about some of the problems with joint assets, but talk a little bit about estate planning when it comes to a cottage. So, often we think about, mom and dad have had this cottage for 25, 30, even longer maybe, and they want to leave it to kids. There's capital gains considerations, there's tax issues. How do you deal with that?
Yeah, I think that, and I'm going to take one big step backwards here. I think that the first thing to think about when you are thinking of transferring a cottage is, I think there's 2 conversations you have to have. And I think the first one is a selfish conversation that you and your spouse and your financial advisor have to have together. And that is this cottage needed for my future, or can I transfer it now, or can I transfer it, or do I wait until my death, etc. So I think that an awful lot of people, I think at that stage, you have to sit down and say, is this asset an important asset for my future? Can I really transfer it someday? And then can I do a very quick valuation of what the tax liability when I die? So there's 2 types, or when I transfer it, there's 2 liabilities. One, if you transfer it in your estate, there's a probate fee. And if your cottage is worth $2 million, we use that because we figured it out. It means it's about $29,000. And the second thing is, there's going to be a transfer of capital gains unless the cottage, there's going to be capital gains tax unless the cottage can be seen as a principal residence, which is exempt. Each couple is allowed only 1 principal residence though, so if you have a cottage and a house in the city, that's going to be a problem. So I think that first conversation you have to have with your financial advisor. But then I think the second conversation, and I hope your financial advisor can help you with this too, is having a conversation with your children and talking about, do they want it? And if they do want it, can they share it? So, you might find, and some of the questions that come up are, who's going to be the general contractor? So who's going to be phoning, the roofer at 3 in the morning when a tree falls on the roof? Can they really agree on how to divide up the time? We had a family cottage in my family, and I have a sister who lives in Vancouver. When we had this conversation, the sister started going, I'm never going to get back to Ontario to see this cottage, so please don't leave it to me, thank you very much. So I think it's important to have that conversation about practicalities about whether or not the children can share it. And then I think it's important to talk to the children about, if you are going to share the cottage with various family members, have you come up with a co-ownership agreement that dictates everything, like who gets the cottage in July, to who's going to be the general contractor? How are they going to pay for this? I have a brother who's done very, very well for himself, a sister who's not done very well for herself. How are they going to contribute equally to that cottage? And I think only once you've had those 2 conversations do you go on and start talking about, how do you transfer the cottage? I think the first thing you do is calculate what the potential tax liability is going to be, and then try and figure out vehicles that can reduce that tax liability. And the most appropriate one there is, I think we didn't talk about it much, but the alternative or joint partner trust. Do you put it in one of those trusts to avoid probate fees? Do you put the cottage itself in a trust after your death? It's not going to avoid any taxes, but at least it's going to mean that your family has some time to think about it. But also, do start using income replacement tools to help pay the tax liability that's going to be incurred. It's a conversation about insurance. If you don't have enough taxes, I think I don't have enough money to cover the taxes. Do you do all of those sort of things too? I think that's sort of not a great answer, but that's my answer for today.
Yep, and I mean, the tax is a big issue. It's very hard to deal with the tax other than to either save to pay the tax or to buy life insurance against it. Really, those are the only 2 options. You know, the tax will happen. It's just a question of when you want to pay it, and if it's how important it is for you to keep that cottage in the family. So that's great. Let's see, we answered this one. Here's a really good one. How can I protect a beneficiary? For example, how could you protect your son Jack from future divorce complications?
Okay. Under the Family Law Act, and I think it's Section 2, but it might be Section 3 or 4. I can't remember. One of the early sections. There is property that is exempt from calculation when you divorce. So when I divorce, in the very, very if I divorce, in the very, very simplistic example, what you do is you take the value of all assets that you're leaving the marriage with, and the value of assets you brought into the marriage. You subtract the brought in from the assets you take out of the marriage. You divide by 2, and that's what you owe to your spouse. And this rewards long-term marriages. So I got married when I was reasonably young, just finished law school, had a lot of debt, not much assets. So let's say I was worth 0. Today, let's say I'm worth $2 million. 2 million minus 0 is 2 million. Divided by 2, I owe Chris $1 million. And then we do the calculation for her. But there are some property that is exempt from that calculation. You don't have to include it. And one of those is gifts or inheritances received are exempt as long as the deed of gift authorizes the gift and the growth component of that gift is exempt from inclusion. So in my will, I can have a clause that says I leave half my estate to Jack, half my estate to Hannah, and then I can have a clause later on my will that says, it's called a family law clause, that says the gift being left to Jack and Hannah plus the growth component are deemed to be gifts to them, and this protects them from calculation on net family property on divorce. If Jack takes that money, so he takes his half of the inheritance and he commingles it with Kelsey, or if he or they go out and they buy an asset together, they buy a new house or a cottage or whatever, that protection is lost. He has to be able to show that that asset has been kept separate and apart from their matrimonial assets for that protection to last. But that's one thing you can do. Okay. I guess the other thing is ask your children to enter marriage contracts, but good luck with that.
Yeah, no, good luck with that. That advice that I give to clients generally goes on. It's very unpopular.
Yeah.
You'd referred to 3 ledgers that the executor needs to keep. Can you address that briefly?
Sure. So I find this one of the most antiquated systems in the world, and good luck finding someone to actually be able to keep the 3 systems for you. But estates have to have a 3-ledger system. One is assets in, one is money coming out. So when I put $1,000 from my bank account in, it goes into column 1. Column 2 is monies I pay out. So it's paying the tax liability and stuff like that will be in column 2. So that's no different than debits and credits. And then the third category is interest earned on interest for capital gains earned on investments. So my third category is I have to have a category that shows the increase and decrease from investment income. Those are the 3 categories that are required. And if you don't have it in that form and you move for a passing of accounts, the courts will not hear the passing until you put your records in that form.
Okay. So that's awfully complex, as one would expect.
It is.
Yeah.
And it's hard. Yeah. It's hard, by the way, to find institutions that will put records in those 3 categories.
So, and then we had a couple of questions, 2 different ones about dying intestate, which we never recommend. First of all, dying is bad, and the second, dying intestate is even worse. So, always get a will is the short answer. But the question is, if you pass away intestate and do not have any family or relatives in Canada, what happens then? That's question 1. And question 2, if you pass away intestate and one of your children has predeceased you, does money go to the grandchildren, or are they left high and dry and it only goes to other kids, for example? Okay, so the first question about you don't have any family in Canada, I'm going to change it to you don't have any family, because it doesn't matter where the family lives throughout the world. If you have a second cousin out there and he lives in England, that's your beneficiary if you die intestate. Very few of us die with absolutely no relatives, because intestacy goes through your family tree as far as you can possibly imagine. There's,
if you have a spouse, if you don't have a spouse, if you have children, if you don't have children. So it goes quite a distance. If you absolutely have absolutely no family, and so you die intestate and you were the last of the family reserve, so to speak, there is an act called the Escheat Act, and it says that your property escheats to the federal crown, so it goes to the federal government in that instance. The second question you had was with respect to what happens if I have two children. So I'm going to personalize this to me so make sure I understand it. I have Jack and Hannah. Jack dies, but he has the three boys, Winston, Farley, and Louis. On an intestacy, Chris will get the first $200,000 and 1/3 of the remainder. Hannah will then share half of the money set aside for the children, and the other half will go to Jack's issue. So it will go to his children. So the intestacy does allow you to go down the family tree like that.
That's a relief. But again, even if you go get a,
but you've got to,
yeah.
Well, and I've got a bigger problem than that, right? My bigger problem is that I don't have a trust for the grandchildren because I don't have a will. So although Winston, Farley, and Louis will inherit, they're like 5, 3, and 2 years old, or 5, 3, and 1 years old. As soon as they reach the age of 18, that money will be payable to them. There is no trust saying when it gets paid to them. Mm-hmm. During the time that before they're 18, there is no guidance about how the income can be used for them. There's absolutely nothing available except to hold it in this bare trust for them.
Exactly.
And since there's no trustee for them, it could well be that the government public guardian trustee becomes the trustee. Sorry.
Yeah, and you don't want, even if they're legally an adult at 18, you don't want an 18 or 19-year-old getting hundreds of thousands of dollars potentially. It may or may, depending on the time, may or may not get spent properly.
Yep.
In the way that you'd like. Another question, is it a good choice to appoint your family lawyer as your executor instead of a bank trust, or I guess a corporate trustee? People are calling it a bank trustee, but it's really actually a trust company, but it may be affiliated with your bank.
Yeah.
But is it a good idea to appoint your lawyer as executor? And in this case, the person's lawyer is older than her, and if he passed away, they're saying the file would pass on to his successor in his business, which I don't know, sounds like a terrible idea.
And I think, I mean, you can do it. First of all, will your lawyer accept the appointment? Mm-hmm. Is your lawyer well versed in estate and trust law? Because I think they should be if they're going to act as executor. And you're right. I mean, part of the problem is lawyers retire, lawyers that die, and the clause I'm sure that's appointing the lawyer will say, Bob Smith. If Bob Smith is not available, then a partner in the firm of Smith, Smith, and Smith. So it's possible to do it, but you're naming an executor you don't know. Mm-hmm. The one advantage of a trust company is there's going to be someone who's who is professionally trained to act as an executor. You don't know when Smith, Smith, and Smith, after old Mr. Smith leaves, whether there's going to be anyone trained in estate law at all to take it on. So I think there's some downsides there.
Okay. Another question here is, I guess actually this one you more or less answered it, but in terms of fine art, a few people have asked, they probably have some fine art that's a little bit more than your HomeSense print that I may have on my walls, but
yeah.
Obviously, how does that relate in terms of probate tax and so forth? So could you address that?
Yeah. And there's a legal answer and there's a practical answer to this, right? The legal answer is that is an asset of the estate. It has to be valued for estate purposes and tax has to be paid on it. Mm-hmm. Any capital gain over the first $1,000 on that art would have to be added to income in the year of your death. And it's going to attract probate fees because it has to be disclosed in your will. And one of the whole purposes of the estate information return is to try and catch stuff like that, to say, okay, we're auditing this particular file. The guy doesn't seem to have a car. The guy doesn't seem to have any household furnishings. That might trigger something. It might not, but it might. The non-legal answer, the sort of practical answer is who's going to know? My artwork on the walls right now, if Jack and Hannah can agree to it, and my will says, distribute what personal assets there might be around my house, I don't think that the Minister of Finance is ever going to knock on Hannah's door and say, where'd you get that painting from? So the The legal answer is you run the risk of the estate information return being audited and then coming back and saying, really, he didn't have any art at all. Let's talk a little bit about this. But the practical answer is, you know, it's difficult to see that the CRA is going to come back. There are a lot of lawyers in Ontario who are recommending to people with big art collections, and they're recommending that they have a second will to cover that so that it avoids probate. Right. And in fact, the first case where there was this dual will situation was a situation where the guy wrote the dual will not because he had a huge company, but because he had a huge art collection and he was protecting it. So that's another thing you can do that will avoid the estate information return and avoid probate.
And I guess one of the reasons why that makes sense is because the stuff, the possessions or the assets that flow through the primary will that will go to probate, those are the ones where the bank will, or the trust company or whoever's managing it, will want to see, land registry will want to see a probated will before they'll do anything in terms of changing the name on the assets. Whereas the shares of a company or your art collection can be easily transferred either by a signature by your lawyer or just simply by putting them in a moving truck, right?
Exactly.
So, yeah, so it's a little different. You know, understandably, banks and the land registry, et cetera, are very, very reticent to do anything without a probated will. They really want to make sure they're giving it to the right person and protect themselves.
Exactly. Yep. Great.
Let's pick up another couple of questions and then we'll wrap it up. Here's a case where elderly parents have the home joint with their two sons to avoid probate. And this kind of gets back to what you were talking about, the cottage. How at this point now, one son wants to sell and the other one doesn't upon the parent's death. So, you know, that, how do they resolve that? So the parents will have passed away, but one son, you know, would rather take the cash and the other one would like to keep the family home.
Yeah, I mean, first of all, I hope they can negotiate some sort of agreement between them where the one son buys out the other son, because what a horrible situation to be in, where, you know, these two sons are going to fight over the family home, and hopefully one of them will be able to buy out the other one and come to an agreement. I think what concerns me about this case a little bit is there are certain ways that joint assets sever. So just because you put something in joint name doesn't mean it remains in joint name forever. There's about 4 or 5 ways to sever a joint tenancy. One is by a unilateral act. So if the one son decides, you know what, I don't want to be joint owner with my brother anymore, he can register a deed transferring his interest to himself, and they then become what's called tenants in common. And after that, there is no joint asset anymore, and the one is free to sell his interest in the property if he so wants. So I think they run down that rabbit hole of one of the brothers taking a step to try and sever the joint tenancy. A joint tenancy can also be severed by the behavior of the parties dealing with it as if it is not a joint asset. So they might find that you end up in a terrible lawsuit about whether indeed there is a joint asset anymore because it might be severed. I really hope they can either resolve it between themselves, or the parents consider transferring it back to themselves and deal with it in their will, because it sounds like just an awful situation.
Yeah, that sounds really difficult. And anyway, ideally, it can be negotiated ahead of time. There's a couple of questions that are a little outside of the scope of this presentation. I guess, how do you stop I don't know, alter ego trusts maybe a little bit beyond what we've been talking about today, and probably would require a 1-hour presentation, I think.
They're pretty long.
But you know, we'd be happy to take that offline and work
Sure.
related to that. I guess the last question we'll take 2 last questions. One is, and both are related to being non-resident in Canada. What are the tax implications when a beneficiary is a non-resident alien who lives in the U.S.? So one of your beneficiaries, I leave this to my brother who lives in Phoenix, for example.
Yeah. Let's see if I word this properly, and you jump in where I'm wrong, because I'm probably going to screw up the explanation of this. We tax capital gains and we tax income. We don't tax gifts. So the funds, the capital itself is going to pass to the beneficiary. I mean, this is a complicated question because it depends on the inheritance tax in the United States too, and a whole bunch of things like that. So I'm not really sure I can do much justice to this. The issue from the income tax point of view, subject to the inheritance tax in the United States, is going to be the growth in the estate after the date of death. It's not going to be the capital value at the date of death. It's going to be that the money has sat invested and it's earned $25,000, $30,000, and that money is going to have to be paid to the beneficiary and might be taxable. I did a bad job of that. I'd like to send that guy an answer if we could get the question from him.
Yeah, yeah. Please feel free to send that question separately. But
yeah,
in essence, in the U.S., inheritance is taxed, unlike in Canada, as income, but there is a minimum, and there's some kind of a, if I recall correctly, a net worth test that's quite high, but depending on how well your family member has done or your beneficiary has done in the U.S., that may be quickly hit. So that's something where, you know, a cross-border accountant, we can put someone in like that to help with that. And
yeah. And I think there's two issues: whether that inheritance tax, which is over $1 million in worldwide assets, will come into effect, and the other one is, if your beneficiary is receiving more than $50,000, they are going to have a duty to file a U.S. tax return, even though it might show a zero return because of the state limits being so high up there. But I'd like to give better chapter and verse on that than we have right now.
Yeah, no, and I think that one's one of those annoying answers where every situation is different and we need to consider it carefully, which is unhelpful, you know, in a broad presentation like this, but unfortunately it's the truth.
Yep.
Okay, last question. How is your tax? So this is kind of like the tennis players all moving to Monaco. Apparently Monaco is fully populated by ATP and WTA players. But how is your tax jurisdiction determined when you pass away? Is there an opportunity to set up a residence in a low tax jurisdiction later in life and avoid Canadian tax?
I would assume so. I mean, I think the problem you're going to have is you're going to have an exit tax when you leave Canada, which can be quite draconian. So if you're moving all your assets from Canada to Monaco, you're going to have an exit tax when you leave Canada, but you can set up your residence there for tax purposes. So there you go. You can do that.
Okay, sorry, and I'm going to put in one more question because I did promise to answer it. This one actually I'll take, but it's basically the questioner is single with no kids, no spouse, and no partner. They have a will and a power of attorney that for someone that they trust to be their power of attorney for property and personal care, which is fantastic. So they've done the right thing. In terms of registering the power of attorney, there is extra paperwork to when we bring on somebody, and let's say, Keith, you were my client and you said, I have a power of attorney and I would like them to be able to act for me. I'm going to ask you, or I'm going to ask the power of attorney questions about herself or himself, and I want to learn a little bit about them to know their income, what they do for a living, what their assets are, and that allows me to, you know, under regulatory terms, quote unquote, know my client, and that way also know how they're related to it, as opposed to just being somebody off the street. And so there's a bit of paperwork there. What can feel like intrusive questions about the power of attorney, but it's there to protect. Keith, it would be there to protect you and make sure that that person is not doing things that are, you know, that I have a relationship with the person too, and I can guide them in doing things that are in your best interest, not necessarily theirs. So that was kind of an important question. So with that, Keith, thank you so much. That was just about 2 hours of a knowledge dump, and I think everybody hopefully really enjoyed the presentation and got something out of it. I know with the plethora of questions we got, there was definitely interest in the topic, so that was great. Very important, we want to thank Life Institute, and particularly Deborah and Roseanne for all their help, Mackenzie as well. And thank Sherry Ferrari, who put us in touch with the Life Institute and gave us this opportunity to bring you guys a couple of webinars, and hopefully there was some useful information, a gold nugget or two in there. We will be circulating some handouts after the presentation in the coming days from the 2 presentations, as well as recordings of the presentations if there was something you wanted to go back and review, or a friend of yours missed it and would like to hear the topic over again. It's all useful information. So again, thank you so much, Keith. This is
No problem. Anytime at all.
yeah, so great. Just a great presentation. Thank you so much.
Oh, thank you. Anytime at all.
And to all the Life Institute members, thank you for joining the Life Institute. And please stay safe, wash your hands, and we'll all come out of this together. Thank you so much.